Okay, folks, we'll get going here. Thank you for attending. I did want to.
Am I in your way? Do I move over?
I recognize you. I saw you in Pittsburgh yesterday.
Oh, that's right.
Yeah.
That's right.
Anyway, I want to thank everybody for coming. You know, when I first put this program together, Ann told me that it was too narrow and we wouldn't get enough people in here, so I'm sorry for the sparse amount of people. No, this is great. We have a good crowd.
Hey, we need that body warmth in here.
Oh, we need it. I just turned the heat up. I turned the heat up. Anyway, I'm J.R. Richards. I'm the current chair of the real estate section. I'm outgoing. This is the last time that I'll be acting as chair. Randy Sullivan, who's also a local Contra Costa attorney, will be the new chair, and we'll hope to have a lot of in-live programs just like this year, and so glad to see everybody's faces and be back in business in that regard. So it's my pleasure to introduce Neil Kalin. He is Assistant General Counsel for CAR, California Association of Realtors. And the neat thing about Neil, other than other things I'm about to tell you, is he is instrumental in developing the forms for CAR, not just the real estate residential purchase agreement, but all the other forms that are involved. One of them that I think is really, that I'm involved in a lot, is you guys did a really good job with the residential lease, especially because they kept up on the new Tenant Protection Act and had all those forms like right in place. So it's one of the forms I look at if people are trying to develop their own lease. So Neil and I met through CLA, California Lawyers Association. That used to be the state bar, and then they broke off and do a different thing. He was the chair of the real estate section for the whole state. And him and Tom Lombardi, tremendous leaders. Like when I joined, I didn't know what I was doing, and Neil and Tom really helped help me along. And he's got some great stories. He kind of a practical joker. He likes to play practical jokes on people, and we have a lot of fun as a group. So if you want to meet real estate attorneys that are outside of our geographical area, I really recommend joining CLA. I meet a lot of really good friends there. Every year they take on new attorneys. They're always looking for fresh faces. One of the good things is they pay for your travel. Like I went to San Diego, we went to Vegas one time. I mean, they do a lot of neat things. So if you join the group and you volunteer your time, it's kind of worth it. What else was I gonna say? Well, anyway, Neil's one of the people that I've developed a really good friendship with here, and it's my pleasure to introduce him. And here he is, Neil Kalin.
You're supposed to make some announcements about credits and
I forgot about that.
MCLE certificates and stuff like that.
Please make sure to sign in. There's links to the materials online, and you'll get your attendance certificate by email. That's it.
All right, thanks, JR. So it's good to be here. Thank you for coming in this morning. Going to give you some information about the CR Residential Purchase Agreement. And it was substantially revised in December of last year. And there's going to be a number of minor revisions that are happening in just about a month from now. In December of this year, we've determined that that was the best way to do it. Every time we have a major revision, we let the form kind of sit out there in the field for a while and see what people are experiencing, what's working, what's not working, and try to make some adjustments. With any of you who work with real estate agents know, the one thing that's key in our mind when we're making these adjustments is not to increase the number of pages anymore for this next adjustment. So that actually we did a good job. So some of the things I'm going to talk about today, most everything is directed at the form that was revised in December of last year. You're going to see a 622 version, and that's because we had to add the Fair Appraisal Act language in June of this year, because that law took effect in July of this year. So when you see dates, you'll probably see a lot of June 22. And sometimes you'll see something that says 12 of 22, and I'll tell you about what's coming up in just about a month from now. So usually I'm speaking to real estate agents, right, instead of speaking to lawyers. So I tried to focus on 10 things that I thought lawyers would want to know about the purchase agreement rather than things that real estate agents should be knowing about the real estate agreement. I'll start off though just with some things like what was new, what did we do in December of last year that was new, but most of what we did actually stayed the same, although maybe we got a little bit wordier, you know, in creating things staying the same. But here are the 10 things, talking about that grid, the first 3 pages. We've added common ownership forms, which I think has probably more of an interest up here in Northern California than in Southern California, with tenancies in common and with stock cooperatives. What to do about tenant-occupied property, a real big problem, and we're actually making some adjustments in December because of that. What happens when the seller leaves property, how to complete the TDS, the transfer disclosure statement, and when is it actually complete, because that makes a big difference to the buyers and sellers' rates. Dealing with defensible space laws has been a huge problem. It's a terrible problem for members out in the field, and there's not much that we can do about it. It's because of what I think has to be horrible legislation that was passed 2 years ago. And I know I talk to members, I should say, you know what, take this form that you're trying to get your clients to fill out, give it to your state legislature, and have them fill it out without going to their staff and see if they can do it, because they're the ones who passed this law. A little bit about assignments, acceptance and delivery. We allow for entity signatures directly on the form now, which is good, and the appraisal. And finally, something that is new that we're adding for the December version deals with one of the exceptions to the mediation arbitration clause. So let's get right into it, right? So, hey JR, can I make this full screen instead of having this little dinky thing that you left me with to look at?
I don't know how to do that.
You don't know how to do that? Okay. All right.
Just gotta make like one of these.
Yeah, okay, so we'll forget it. I'll put my glasses on. No problem.
Just look, you know, good.
I look sophisticated like this, okay. I just can't see anybody else in the audience.
We're a blur, right?
So what do we do? So what was, you know, what were some of the things that was new? In December of last year, we took this 10-page contract, it became 16 pages, was kind of a shock to a lot of our members. But some of the reasons for that increase was we added this grid in the first 3 pages. We tried to format the agreement better, so there was better page breaks, space breaks. We put all of the dispute resolution clauses on one page rather than having to go over page to page. We have all the signatures on one page because in the previous agreement, the buyer signed on one page and the sellers were on another page and the brokers were on another page, and it was very kind of confusing, particularly for our members out there in the field. And we have some added language because we tried to make some things clearer in the contract. So you put all those things together and the size of the agreement just expanded. But the big difference was we've got this grid. You'll see a clip of it. You're probably already familiar with it, which is on the first 3 pages. And that was really kind of a game changer for our members, right? Rather than looking through a whole contract to find clauses that were really negotiable clauses between the buyer and seller, everything is now up front. And I would hear when the contract was 10 pages, oh, our clients don't read it. They just go through in zip form, the electronic form software program, and they just initial, wherever they're told to initial, which is really no different than it was 20 years ago. 20 years ago, what would brokers do? We're on the field. They had little stickies. They would put the stickies on the bottom of the page, and they tell your client, hey, here's this paper contract, sign or initial wherever you see a sticky. And what would the clients do? They wouldn't be reading all those pages. They'd go, they'd find the sticky, they'd tear it off, they'd initial and say, they'd give it back. It's really no different now, it's just all done electronically. That's all. Okay. So those are some of the things that are saying. Those are some of the things that are different. You know, what's the same? We kept the same process for contingencies and contingency removal. It had to be 15 years ago, maybe 18 years ago, that CAR moved its contract from a passive removal of contingency method, which means what? Contingencies just get removed automatically as a matter of time, to an active method of removing contingency, which means contingencies remain unless they're removed and ready. That stayed the same. We kept time frames in order to accomplish certain things, and we kept some things like a mediation first, or mandatory mediation to resolve problems, optional arbitration, and optional liquidated damages. So let's kind of look at some of those 10 items. The first thing is, we've got that grid. When that grid first came out, a lot of people said, well, okay, so that grid, it's more like a summary, it's more like a table of contents. It's not. The grid is part of the contract, and that language you see right up there at the top, that yellow rectangle, the items in this paragraph are contractual terms of the agreement. You can see the reference paragraph for further explanation. The parties are advised to read all 16 pages, right? So everything here is part of the contract, and if somebody actually looks at the grid, they say, yeah, that makes sense. What's in here? The purchase price. How could the purchase price not be part of the contract? When is escrow going to close? How long is the offer going to be good for? When is the initial deposit being made? How do the loan terms work? Everything in here is part of the contract. On one of the other pages, there's allocation of cost. Who's going to pay for what? Well, of course that's part of the contract, right? And as I say, the benefit of this is, rather than a client looking through 10 pages and now 16 pages to see what is most important to me when I'm negotiating a sale, whether I'm on the buy side or the sell side, I can see everything up front. And for agents who don't like to read, or for buyers and sellers who also don't like to read, guess what? It's a lot less burdensome. And because in this format there's reference to the substantive clauses, if there's something that's of interest to you, or something that's of interest to your client, it's really easy to find out where that is. What does it mean? What do these contingencies mean? How do they work? Great. We're telling you right here in these first 3 pages where to find all that substantive content information. So let's spend just a few minutes on these common ownership forms. Many of you probably never even see these things, but we're hearing more and more about them. They say tenancies in common in stock cooperatives. And why are we hearing more about them? Well, because the median sales price in California is $800,000. People can't afford to buy a home on their own. I mean, a lot of people can. I live in kind of a nice suburban neighborhood. I've lived there for 24 years. I could not come close to affording my house today. But actually, all around me, the homes all around me have sold in the last 3 years. So people are coming up with this money. And it's kind of interesting when I see the people around me who've moved into my neighborhood. In my neighborhood, they happen to be young couples. I don't know if they're married, not married, I don't know. None of them have kids. They got dogs, but they don't have kids, right? And both people are working, right? And so maybe that's how they're able to, and the ones around my neighborhood, because I've a lot of people in my neighborhood have lived there a long time like me. People did after they bought and after they paid an outrageous price for the properties around me. Then they gutted them, right, and completely rebuilt them, right? So people are making money. I don't know how they're making that kind of money, but people are making money. Maybe it's the fact that both are working, right? And maybe it's the fact that, at least for now, they're not saving for college education for the kids because they have a dog and they don't have to worry about the dog going to college, right? Although a lot of people I know send their dog to doggy daycare. So they're spending money on that too. Anyway, so we think we're likely to see these types of ownership vehicles expanding as affordability becomes more and more problematic in California. So how are we dealing with these vehicles? So let's start with tenancies in common. So we have a tenancy in common addenda, and probably the thing that I want to emphasize with lawyers is that the forms that CR has for these other ownership vehicles, they're not the primary agreement. We don't have the tenancy in common agreement between the co-owners, right? Our addendum says this is attached to the regular residential purchase agreement. And it's saying, basically, what are you buying? What unit are you buying? Do you have exclusive rights to parking? Do you have exclusive rights to a deck? Do you have exclusive right to storage? Things like that. That's what we're addressing here, okay? It is not the tenancy in common agreement. Tenancy in common agreement needs to be provided to the buyer, and that's a contingency when you're using our tenancy in common addenda. Okay? Hopefully that's already been created, when the seller initially created a tenancy in common. But sometimes parties are going into something up front and maybe they did not do it properly. You see on that box on the left, qualified California real estate attorney, right? We use that phrase a lot, right? We tell people, if you need legal advice, don't just talk to your local, injury lawyer. Talk to a qualified California, and we always throw in California because we had people say, oh yeah, my cousin's sister's in-law in New York is a real estate attorney. It's like, well, that's great. Are you buying in New York or are you buying in California? Right? You need somebody from California to help you with these things. And so the tenancy in common addenda has a lot of information there. I already talked about the contingencies. But for the TIC, there's also a contingency for review of financial information, because the tenancy in common is not a common interest development under the David Sterling Act. Right? A stock cooperative is, but not a tenancy in common. So we have a form for the management of the tenancy in common to provide that basic financial information as well. We also have an ownership advisory for tenancies in common. The ownership advisory, when you see the word advisory in any of our forms, it means it's informational only. Right? Because a lot of people, they're buying and they don't. Tenancy in common, stock co-op, condo, it's all the same to me. Well, it's not all the same, so we're trying to give them some basic information that they can have available to make a sound decision. And for the tenancy in common, we also have the financial disclosure, since again, a tenancy in common is not a common interest development. For stock co-ops, which is, again, mostly we see this stuff, up in the Bay Area up north. There happen to be some stock co-ops in Southern California, mostly around the Long Beach area, and why that is, I have absolutely no idea. But again, people are starting to be creative to look for ways to buy. And so we're looking at this. So again, we have an addenda, the same thing. What is the buyer buying into? What is exclusively their right? They're going to have to get, look at that stock cooperative agreement. They're going to need approval from the board, things like that. Disclosures will be provided. Again, there's a contingency for review of that document. We did not need to create a separate stock co-op finance disclosure because it's a common interest development. And so the same rules that would apply to condominiums would apply to a stock co-op. Okay, but we do have the advisory. And that takes us to tenant-occupied property. And this is an area where we're making some changes in a month from now. So when we revised our agreement last year, how did we deal with tenant-occupied properties? And we said, we're going to create this separate addendum, the TOPA, tenant-occupied property addendum, that should be used to address, what rights the buyer and seller have if there's tenants in the property. And the default position is that buyer, you're taking subject to the tenant's rights, right? And in California, tenants have more rights than other tenants. And in California, it's almost impossible to remove a tenant, even for legitimate reasons. So we said, okay, let's do that. Let's, use this form, and parties will use the form when there's tenant occupied property. So now that the purchase agreement has been out, for almost a year, what are we finding? Parties are not bringing that form into the transaction when they should be. And if they don't bring the form in, that begs the question, what happens with the tenants? Do they get to stay or do they have to leave? And what are the buyer's expectations and what are the seller's expectations? And right, as a real estate agent, or as a real estate lawyer, that someone who takes property with notice of the tenancy takes subject to the tenancy. But are buyers taking with that notice? Maybe, but maybe not. Right? You've got a lot of buyers, forget about the last month. What about 2 months ago or 3 months ago or 6 months ago? Where they never saw the property, right? They did everything online. The buyer never went in. Maybe there was no disclosure from the seller. Maybe there was no disclosure from the seller's agent through the multiple listing service that the property is tenant occupied. There was no showing, so you didn't have to worry about, posting the signs and getting the tenants out for the day, for the open houses. Now, that's changing with the market now. But you got a lot of situations where buyers had no idea the property was tenant occupied. And of course, that's problematic. So how do we address that as a forms committee and as a trade association? And so there's several paragraphs here. The first one is in the grid, it's paragraph 3M3, right? And occupied units by tenant, and look what it says, or anyone else other than seller. Because in that addendum we created, which the addendum has stayed the same, tenant occupied property addendum. For that purpose, not for all purposes of landlord-tenant law, but for the purpose of that addendum in that contract, we say, who is a tenant? Anyone other than the seller. Why?
Could be a relative.
Because the seller has the relative, mom, grandma is living there. The adult child is living there and says, I'm glad you're leaving, but I'm not. I don't care if it's on the property. I like living in the garage. This is great. Maybe the new owners will be nicer to me. So for that purpose, a tenant is basically a rent-paying tenant, or anyone else who's other than the seller. Okay. So if
question?
In a second, Malcolm. Let me get through the slide, okay? So you see kind of in that middle column there, so if the buyer's aware of it, the buyer should check the box attached to the addendum. Again, we found too often buyers were not aware. And so we're adding this language in the right column. This is coming out in December. And what does it say? Seller shall disclose, right? So we're making an affirmative obligation to buyer if occupied by tenants or persons other than seller. And then a reminder, seller, you're making this disclosure. What do you have to do? You have to attach that tenant occupied property. And guess what, seller? If you don't, well, then the burden is going to be on you, because we're going to see later on what the form says is that for property that the buyer intended to occupy, the default position is it's going to be vacant. So that puts the burden on the seller, who should know if it's tenant occupied or otherwise, to take a step to prevent the seller from having the trouble. And what's the step? The step is such a simple step. Attach that tenant occupied property addendum, go with the default position in that addendum, which is buyer, I've disclosed to you that it's occupied, and guess what? You're taking subject to the rights of whoever is there. Now, if the buyer doesn't want that, the buyer can try to negotiate something different, and the seller will have to think about whether that is practical to do that, or whether there's going to need to be a price adjustment or something else. But we realized by not having that default, there was a gap in the purchase agreement. And we're trying to avoid having gaps, okay? What else do I want to mention here? One of the items that's there is paragraph 7 in the purchase agreement. This is the new one. That If the property is more than 1 unit, so 2 to 4 units, that's what our RPA is for, anything from 1 to 4. Buyer, you have to identify which unit you're gonna occupy. Because that's the only one that the seller is saying needs to be vacant if nothing else happens, right? So, again, we're trying to address some of the gaps there. Here's our tenant occupied property addendum. Paragraph A, that's the default. Buyer, you're taking subject to tenant's rights. Paragraph B is the optional paragraph that says, guess what? The tenants are gonna be gone. But we recognized reality in California that that's really hard to do. And that's why in paragraph B, as long as the seller is making a good faith attempt to remove the tenant, if the seller is not able to do so by the close of escrow, buyer, you then have two basically choices or two remedies. You either take the property subject to the tenant, or you cancel and you're entitled to all of your out-of-pocket expenses back. And we had to do that because we had to recognize what was going on in California. So Malcolm had a question first.
You
Go ahead.
answered it, Neil,
Okay,
thank you.
great.
Can you just extend the escrow while you do the eviction?
No, nothing extends the escrow. Parties can always agree to an extension time,
That's what I'm saying.
right? We have an extension of time addenda, which would be the best thing to use. But again, we just had to recognize that if the parties were going to agree that the tenants were going to be out, most people don't understand what that means in California and how difficult that is. That's why we gave those two options, yes.
Why is there no reference to the Tenant Protection Act in any of these documents? I apologize if that was
Okay.
kind of blunt, but one of the issues that I've been encountering with these tenant-occupied property
Yeah.
sales is the buyer comes back and says, well, I didn't know that this property was subject to the Tenant Protection Act. Why was that not a disclosure? I mean, I think that's part of the disclosures, but if there's a tenant-occupied property addendum that must be attached, shouldn't there be like a simple checkbox that says this property is exempt or this property is subject to?
Okay.
And maybe that's a suggestion in the suggestion box for you.
So that is, and there is language in the tenant occupied property addendum that refers to what we call our form, I know it by code, so RCJC, rent cap and just cause, which addresses that, but the one that's addressed to the tenant occupied property addendum is not filled out because it's there for informational purposes only. And yes, the owner is going to have to make that disclosure eventually to the tenant, but not at the time of contract, because that may not be known at that time.
If I could make one comment.
Yeah.
One of the issues that I have with the new contract is the contract makes reference to attachments. And I should have asked you the question earlier concerning the contingency removal. That puts the burden on the agent to know that these documents have to be provided. And more often than not, in the past year, most of my seller-buyer disputes have been, well, the agent didn't provide this document to me. I did not know that I had to fill out this document. So I guess the comment that I'm making is that the CAR form, I think, is a lot more intuitive for lay people to read and understand. But I believe that the burden is still on the broker and the agent to make sure that they are fulfilling their obligations to provide all of these addenda. So perhaps there needs to be maybe some sort of additional documents added to the RPA to make
Okay.
it even longer. I
So,
don't know.
well, so the issue is, when is it gonna be done? Is that gonna be done at the time of an offer? The seller's not gonna be making disclosure when the buyer's making an offer. That doesn't make any sense. The seller's gonna have to be able to do that at some later point in time. In terms of addenda to the purchase agreement, 99.9% of all agents do forms electronically, right? No, basically no one does forms in paper version anymore. So electronically, if there's an addenda that is referenced in the purchase agreement and the box is checked, the software program will automatically bring that in to the transaction. There's nothing that needs to be done. The software cannot fill it out, the agent has to fill it out, or the principal has to fill it out,
Right.
but any addendum will automatically be brought in. But anything that happens after the time of the offer, that's something that agents have to know what to do.
One, and I apologize, one follow-up question. So if an agent fills out an offer and checks the box contingency removal, are they prohibited from also putting in a different time frame for the contingency removal? Because I'm actually in mediation right now where the agent wrote in 14 days for contingency removal on an appraisal contingency and also checked the box removal of all contingencies. And so that inherent inconsistency in the contract is why I'm trying to solve this problem. So is it a program issue or is it just a agent didn't do their due diligence?
Okay, I don't think that's a programming issue. So the contract has a default time for contingency removal, which is 17 days, and that can change because you can write a different number to the contract. And there's an option to check a box to bring in a contingency removal with the offer, right? There's only two contingencies that can be removed in the body of the contract, loan and appraisal. Any other contingency that you're going to remove, you have to do it by a separate document, the contingency removal form.
Okay.
That form, if you check the box, will be brought in with the buyer's offer. I have to tell you, I'm not your mediator, I don't know what your mediator is going to say, but it seems to me that a subsequent document that specifically is addressing contingency removal is likely to be more, to supersede the generic language in the purchase agreement. But that's for your mediator and your parties to figure out in your particular transaction.
Hey,
Okay.
I think Malcolm still had a question. Did you ever get, no?
No, he answered. my
Oh, okay,
question.
I apologize.
Thank you.
All right.
Appreciate it.
Okay, let's move on. Personal property. So just like the contract has said for probably 20 years, seller, you have an obligation to remove personal property and debris upon the close of escrow. And this year is what happens if the seller doesn't. This is something that was addressed in December of last year with a statement. It's hard to see. I know I used red. I didn't make it light enough. But we have an affirmative statement here now. Seller, if you leave anything, it is deemed abandoned. Why did we do that? Right? Because under landlord-tenant law, if a tenant leaves things, it's not automatically deemed abandoned. The landlord has to give a notice, what is it, a 21-day notice, and then, depending on how much it is, file something with the county recorder and publish or whatever. Kind of ridiculous. And people are saying, do those same rules apply to a buyer-seller relationship? And we're saying contractually, no. Seller, if you leave it, it's deemed abandoned. All right, buyer, then what can you do with it? Maybe you don't want the seller's junk car that the seller left there. So now you want to get it out, right? All right, so what we say is, buyer, if you want to get it out, you want to charge the seller for those costs, which I think would probably be the case under common law anyway, but now we're making it explicit. Buyer, if you want to charge the seller for the cost of having the property free of debris and personal property, seller's personal property, what do you have to do? You have to give the seller a notice. Come, get your stuff within 3 days. If you don't, I'm going to take care of it my own, and I'm going to charge you for it. So people ask us, where's the form to give the seller that notice? Well, we said it's not really a form, but any of your agent members who use our programming will know we created a separate library. The legal department created a library, not our standard forms department. The legal department created a library in zip form with a bunch of letters, and there's like 20 different letters in there. And one of the letters is a notice from the buyer to the seller that says, get your stuff. Okay?
Where do you send it? I mean,
Yeah, good question. Where do you send it? And that's my question right here. It's a good question, right? Where do you send it? So, if you happen to know where the seller is, send it to the seller. If you don't know where the seller is, I would suggest sending it to the seller's agent or the escrow holder.
or your address and they forwarded it. So,
If they have a forwarding address, I think that's a perfectly good response. When we did that, though, we said, really, the legal agency relationship terminates when the purpose of the agency has been accomplished. What was that? The sale of the property. So can't you say, if you're a seller's agent, my agency relationship terminated, I've got no more relationship with the seller, don't send anything to me. So we actually created another letter.
A letter for the letter.
And that other letter is basically the seller's agent saying, I will receive this and I will forward it, but don't misinterpret this. I am no longer an agent in this transaction. Basically, I'm doing this as a courtesy from this point forward. And that's also found in our letter library, so I end up go up in the back.
So I'm curious, how does the buyer collect on the fees that they've incurred? I mean, would it entail another lawsuit? Is there language that says, hey, you escrow, you need to put reserves so that the buyer is compensated for the cost?
No escrow will hold reserves for that. And no buyer's gonna know how much it's gonna cost either. So how's the buyer gonna collect? The same way the buyer collects when the buyer moves in and finds out that the toilet wasn't fixed, or that there's still a crack in the window, or that, some other item is broken that was supposed to be repaired. The buyer will have to pursue the seller, whether that's in small claims, but first making a claim in mediation, and afterwards try to locate the seller. And if you can't, something, there's just some problems that are inherent in the transaction, and that could be one of them.
So is it better to have that language or go by the statutory scheme that allows you a little bit more leeway in collecting your fees? Because the examples that you use, usually buyers get home warranty, and the majority of that stuff, if your AC breaks down, your dishwasher breaks down, it's covered under home warranty. But what's the remedy here?
Well, that's irrelevant to this paragraph. This paragraph is seller's crap that was left behind. Okay? It has nothing to do with a dishwasher or an air conditioning or a heater that the buyer was purchasing. This is stuff the buyer was not purchasing. Okay? So I agree, for anything that was part of the purchase, the buyer, if you've got a better avenue, use that better avenue. Don't spin your wheels. Don't go hiring one of you to collect something that's uncollectible. If you've got a home warranty plan, that's fine, but that does not help for personal property that was left that was not supposed to be there.
Neil?
Yeah.
Why can't there be a clause or a paragraph that says, seller shall get his crap out no later than 3 days before close of escrow, and if he doesn't, then buyer has the right to cancel the contract?
Because then the seller could be left sleeping on the floor for 3 days if they've had to get everything in personal property.
And that's one of the good reasons. That's where you have the balance between what's practical and what would be nice and clean legally. That would be great, nice and clean legally, but sellers don't want to get everything out, A, because they don't want to be sleeping on the floor, 1, and 2, what do we hear? We hear this all the time. Sellers take care of everything, and the buyer doesn't close, so now the seller's left still with their property, and everything's gone, right? So we've got to balance those two competing interests.
The other question is probably a small claim court issue. Does the mediation provision kick in first?
It is, because this is a provision of the contract.
Do you have to mediate the crap issue before you can go to court?
If it's small claims, the answer is no, because there's an exception written into the mediation clause. Gentleman in the back.
I was just going to say that in practice, it actually doesn't really come up that often, because most brokerages will require a VP or a verification of property. They require, before the agents even get paid the commission, they have to finish the file and complete a walkthrough. So there's a little bit of mitigation that the buyer, that's the onus on the buyer as well, to walk through the property, look at the agent visual inspection, so the agent also does their visual inspection of things that they notice. So it really is funneling down to a very narrow circumstance.
Yeah, I have to tell you, there's a lot of hands raised, but I think we're spending more time on this clause than it deserves. So I'm going to move on. Fully completed transfer disclosure statement. So under the law and now under the CAR purchase agreement, a fully completed transfer disclosure statement is defined as one where sections 1 and 2 are completed by the seller, and section 3 is completed by the seller's broker. There's a section 4 for the buyer's broker to do their own investigation and disclosure. That's not part of creating a fully completed transfer disclosure statement. And the reason that's not part is, why? Because then every buyer's agent will say, well, I just won't do an inspection until the day before close so that my buyer has this automatic right to cancel. Because the statute says a buyer has a right to cancel prior to receiving and within 3 or 5 days after receiving, if it comes after the offer is made, a transfer disclosure statement. So that, I think, makes intuitive sense. The part that was problematic and that was added last year was that part about Section 1. And Section 1 is a little bit weird and kind of hard to understand. And here's the TDS. And what Section 1 says, coordination with other disclosure forms. And this has been in the TDS for 35 years. And it basically was, I would say, ignored for 33 years. And then some lawyers started getting creative and saying, you know, I don't see anything checked here. Now, it could be that nothing applied, so maybe nothing needed to be checked.
Like the other inspections people get.
Like the other inspections people get, right? And so what does it say here? Under this Section 1, there's this block that's called substituted disclosures. And good for you if you're able to figure out what that sentence means. It's been there for 35 years, okay? But if we look at the last part, it talks about, you know, other reports that are intended to satisfy the disclosure obligation of this form. Well, what inspector do you know that says you can use my inspection in place of your own disclosure, seller? None. None. Not the NHT companies, not the home inspection companies. Nobody will say you have the right to use this in place of making your own inspection. So we're saying, what on earth could possibly fit into this category? And the way I like to think of it is a substituted disclosure is a replacement. What sellers normally provide are supplemental disclosures. They supplement everything else that the seller may already be providing. And so CAR took the transfer disclosure statement that we prepared and we added that box in the bottom. You see a circle around it. It says no substituted disclosure for this transfer. And I think in almost all cases, that's the box that probably should be checked. Okay, Jared.
So the reason is that there were lawyers contending that if you didn't put anything on that list, for example, a supplemental inspection or anything, that you couldn't rely on that as a disclosure. Is that what it was?
What I think
Yeah.
was happening is lawyers were saying nothing is checked in this paragraph. I don't care whether you provided things, you did not provide things. I don't care if I'm client is looking at them or not looking at them. Since no box was checked, the form was incomplete. And therefore my buyer client has the absolute right to rescind this contract. Okay? Now, I think if no box was checked, I would have argued they didn't apply. Nothing needed to be checked. But we started hearing more and more our lawyers making that argument. And we're like, well, that's not good for the industry. You know, for quite honestly, something that may have thought was made sense when the TDS law was enacted over 3 decades ago, but really doesn't make sense with the way real estate works today. But nobody wants to go in to the legislature and say, change something. Because anytime CAR proposes legislation, there's all sorts of interest groups that will oppose us just for the sake of opposing us, or thinking that we're trying to get away with something, even if we're just trying to make something make more sense. And so it's like, you know what, it's probably easier just to add a box. Agents, instruct your seller. Almost every single time, there's really going to be no harm in checking that box, fill out the rest of the TDS like you would, and then we avoid that problem.
What's the harm in checking the box substituted disclosures and just saying any and all reports received by buyer?
Because they're probably not substituted. They're probably not intended to satisfy the disclosure obligations of this form. That's not the purpose of those disclosures. So that's what I think is the risk in checking that box.
I agree, but I've never seen that come into question. But it's always treated as a supplemental rather than a substitute. I don't see the harm in supplemental.
And to me, listen, I think the last box that we added is the one that should most likely be checked. If the first box is checked, at least you're getting rid of the argument that nothing was being done in section 1, right? Something is being done. To me, it doesn't really make a lot of sense with the way it's worded, but at least that argument goes away. At least the argument that the buyer's lawyers had, which is the form is not complete because no box was checked. So I would agree with you that there's an advantage. I think to me the better approach is the last box, but you know, people will advise their clients different ways.
Do you think the substitute disclosure box connects to 1102.4?
Well, tell me what 11.2.4 says, and maybe I'll tell you.
It's a defense when there's an error in a report and the seller's not responsible for an expert's error in that report.
I would say maybe, but you know, it's interesting. You probably see that. I don't hear a lot about that issue ever being raised, about errors or inaccuracies in a professional's report. All right, so let's deal with some other issues here so I can get us out of here on time. This deals with the fire zone laws, and there's 2 fire zone laws that were recently adopted. One is dealing with fire hardening. What's fire hardening? Making a structure less vulnerable to wildfire, less vulnerable during day. The other one is the defensible space law. Defensible space, there's state and there's local laws that say the area around the structure has to have mitigation measures to protect or to prevent the spread of wildfires. You've got to cut grass, you have to, trim trees, you can't have anything overhanging the roof or the fire or the chimney, things like that. The law concerning home fire hardening is easy to comply with. Seller, you disclose what you know, okay? Seller, and I'm going to get to that in the next page, I'll just do that right now. There we go. For fire hardening, seller, do you know if your rain gutters are without metal or non-combustible gutter covers? Do you know if there are loose or missing bird stoppings or roof flashings? And then good luck explaining to your client what a bird stopping is or a roof flashing is, right? But it doesn't matter because that's a very simple question. Seller, are you aware of these things? If you're not aware, real easy, just check no. You're not saying they're not there, you're not saying they're there, you're saying I'm not aware of it. Fire hardening is easy, home hardening is easy. Defensible space is tough because there's state laws and there's local laws. And when the law was first enacted, there's really only 2 local laws that we are aware of. They're spreading all over the state where there's fire areas. Right? And even then, if it was simply a disclosure, seller, is your property in compliance with the state or, if applicable, local law, make that disclosure. That might even be easy enough. But what the law says is, buyer and seller, as part of your contract, you have to agree who's going to be responsible for defensible space compliance. So the law says this has to be part of your agreement. Well, the buyer's not going to know if there's compliance already. How do you find out? Well, if you're a seller, how do you find out? Well, not that easy to find out. Maybe you call CAL FIRE, and CAL FIRE will come out and do an inspection and let you know. But maybe you have to call your local fire marshal. And then with each of these things, the state law allows a buyer to bring the property into compliance after close of escrow if the state law applies. Local laws have different approaches. Some allow the buyer to bring the property into compliance within a certain period of time after close of escrow. Some require the seller to bring the property into compliance before close of escrow, basically a point of sale. So really hard to figure that out. Now, we advise people, when you take a listing, go figure this out at the time of your listing. Figure it out. And then, once you figure it out, maybe get an inspection. I think it's advisable for a seller to get an inspection. So the seller will know, what's it going to cost? Do I have to cut down some, 150-year-old trees? And what if they're protected? you know, under the tree rules in California, right? How much is it gonna cost, right? Now, 3 months ago, this was not an issue, right? So the law took effect July 1st. It wasn't an issue in July 1st because no seller was gonna take care of this, right? Seller said, you want my property, you're taking my property, no contingencies. You're gonna take it as you find it. You'll pay to bring it into compliance afterwards. You don't want my property, buyer? Tough. Go find another property where the seller will tell you exactly the same things. Now that the market has shifted, buyers are thinking, well, I don't want to buy a property with this unknown expense. And it might be a little, but it might be a lot, right? So that's why at CAR we advise listing agents tell your sellers to find out at the time of listing what this is going to cost. Then you could bake that into the purchase price. Either way, whether the buyer is going to bring it into compliance later, or whether you, the seller, are going to bring it into compliance prior to close. But it's a difficult thing. It's hard to find out. It's hard to get answers from the local agencies. It's difficult to find out, and that's why this has become so problematic. Question, I'm moving on.
So there's no private agencies, you know, doing this like the natural hazards and these flood zones and that kind of stuff? Because fire marshal, I mean, they've got limited resources. They can't be going to every property.
Yeah, I think they like to go out to every property because they're not doing this for free. And not the fire marshal, the Cal Fire, the state agency. And the law does not require an inspection prior to the sale. The law does not require that. Cal Fire has on their website, every property that's for sale needs an inspection. Cal Fire is absolutely 100% wrong under the law. We've had discussions with them. They don't care. Their position is every property is required. Now, if they want to say every property is advisable, we'd have no problem with that. They're keeping on their website that is a requirement. That's fine. Give us the legal support for your position. None. None. But their position is basically, we don't care.
What's it cost? What's their inspection?
I don't know. I'm sorry. I don't know. So, anyways, that's one of the problematic areas. Thought I'd make you as lawyers aware of it. Okay, assignments. How do we deal with assignments? So in December of last year, we added a more extensive assignment clause. Previously, we had an assignment clause in our contract that the buyer had the right to assign. The seller had the right to disapprove. The seller's disapproval had to be reasonable, whatever that language that most of you are familiar with, okay? Could not be unreasonably withheld. And then we started getting issues with buyers making an assignment right up to the edge of the close of escrow date. Well, that put the seller in a real terrible position, right? So one of the things we added to this clause was, okay, buyer, you want to make an assignment? Has to be done within 17 days after acceptance of the contract. After that, the seller has absolute and sole discretion to not accept the assignment. Okay? Does not have to be reasonable after the 17 days. All right, but how do we deal with other issues? What about trust? What about single purpose, wholly owned entities? So we said, all right, buyer, you do not have to seek the seller's consent if you're assigning to your own trust or a wholly owned entity. It's really kind of like a replacement for you, right? It's really not a true third-party assignment. But there's other requirements that even a trust or a wholly owned entity need to comply with, right? You need to provide the name to the seller. You need to let the seller know if there's any compensation going from the assignee to the assignor, which is usually not going to be the case with the trust or a wholly owned entity, but those things need to happen anyway. And probably one of the big ones is if the buyer was getting a loan and needed to have a pre-qual or pre-approval statement, which they provide up front, then the assignee needs to also provide a pre-qual or pre-approval statement. Because lenders are really concerned when somebody's assigning to a trust, that trust has the ability to perform under the contract. So even where there's exemptions from seeking seller's consent, there's other requirements that still need to be met. The other thing that we did, it's in the red at the bottom of that top box there, is dealing with nominees. Now I know for years I've been saying never write in buyer or nominee. Never write in buyer or nominee in the name of who's doing the purchase, right? And then I never had to even look this up for years. And then all of a sudden we're finding parties are still writing in nominees. So I'm like, well, maybe I should research again what that's all about. And I research it, and basically what's a nominee? It's somebody that in this case it's always going to be a buyer, that the buyer appoints to take their place. But the nominee is really an appointee, and the nominee has no obligation to fulfill the terms of the contract. So you're basically saying, I'm not going to do it, I'm going to let JR take over my contract. And JR's like, what are you talking about? I have no obligation. Neil, you just can't nominate me out of the blue. And then what's the seller left with?
Nothing.
Nothing, right? And so that's really problematic. But we still see that being written into contracts. So we're adding language next month that says a nominee, for the purpose of the contract, is going to be treated exactly the same as an assignee. For contract purposes, we're not distinguishing between two of them, and you have to provide the names of the escrow holder, because escrow holders are kind of freaking out whether it was an assignment or a nomination, which is, who am I preparing these escrow instructions for? How am I doing the final closing? So those are a couple of things that I thought you want to be aware of. We have an assignment of an agreement addenda that we prepared that goes through all these issues, providing documents. The assignee, by the way, does not have to sign and initial every page of every document that was already provided. They just have to sign the first page on all of the documents, or initial the first page on all the documents. But we've got this assignment of agreement addenda, and I know a lot of attorneys like to create their own. That's what you want to do, all the power to you, but we have one that's available, and it can really be used for two purposes. It can be used as the assignment from the assignor to the assignee, and it can also be used as the approval by the seller when the seller gets proper notice of the assignment. Okay. All right, 8. Well, I'm on 8. I got, what, 10 minutes left? 5 minutes left? Okay. When is a contract created? Well, we changed the language. When is a contract created? Under the new contract, a contract is created, a binding acceptance, okay, when there has been delivery to the principal or the principal's authorized agent. Who's an authorized agent? Authorized agent is defined in the contract, and it's basically the licensee who's named on the last page of the purchase agreement. So once you have delivery to the agent, there is a binding acceptance, okay? What does delivery mean? It means personal receipt, so this is paragraph 25K. But we also provide for delivery electronically. And this is our recognition of reality. People today are doing business electronically. Nobody's bringing a piece of paper over to the other side and saying, see, here it is, you've got the acceptance, or sending it by mail, or whatever. Everyone's doing business electronically. And so what we're saying is, delivery is effective electronically once you hit send. You no longer have to approve, was it actually received, was it open? Once you hit send, but only if, and this is the key, only if the side that you're sending it to, you send it to something that we call a designated electronic delivery address. So they're identifying up front, if you send something to me, once you hit send, that's effective as long as you send it to this particular address. Okay? How do you find out? And by the way, you can send items directly, or you can send with attachments, you can send a link. Okay? There's ways to object to a link, but I don't have time to get into that. On the last page of the purchase agreement, where we have the agent's signatures, and this has been reformatted for December, but you have this line for designated electronic delivery address. And it's either going to be the general email address for the brokerage named above, it's going to be the general phone number or text number for the brokerage named above, or you check a box and you're going to put an alternate, because maybe the agent that's writing it says, I don't want anything to go to my broker, I want it to go to me specifically, right? And so I suspect when this gets filled out, probably the better way to have it filled out is to have that alternate address put in, because the agents want to know if their clients are in contract. And that delivery is effective even once you are in contract for all the various documents that get sent once a contract has been formed.
That's good. Like notice to perform, that's good.
Yeah, any of them, notice to
Yeah.
perform,
Yeah.
demands to close, anything.
Yeah.
This is one of the forms. It's actually a very little used form. I'm hoping it's used more now. And if by chance something was sent via a link, there's a way to identify it in this request for repair form. But I don't need to go into that. And so this slide really is just to show what a changes has been right from the old common law rule, right? Acceptance was when something was deposited in the mail, whether the other side knew about it or not. Whether it took a day to get there, or a week to get there, or a month to get there, it didn't matter. There was acceptance, right? And then we went to personal receipt, and now recognizing the reality of electronic transaction, it's a little bit like the mailbox rule, right? Because it's when sent. So almost coming full circle, but just for that electronic delivery, and only if that designated delivery address line has been filled out. This last one, entity signatures, just want to let you know, when you had entity buyers or entity sellers, they had to use another form to identify the entity. Now there's an ability to do that directly in the body of the purchase agreement. And so I know you got the material, so I gave a couple of examples of this way this would work. It's a little bit tricky when it comes to trust, right? Because a trust is not truly an entity, but most people think of it as an entity, and nobody names a trust the right way. And nobody, whether it's a buyer or the seller, it's like, oh, well, it's, Neil's trust, or Neil's the trustee. It's like, well, okay, so then, great, put Neil Kalin trustee. I might be the trustee of my trust, and my parents' trust, and my children's trust. Which is the one? What are you talking about? Who's going to be bound by this contract, right? So the way this paragraph is set up, you have to identify the trust by its full legal name. Then if you want to use a shorthand for the purpose of the contract, fine, it doesn't matter, because you've identified the actual item. Real quick, and then I gotta move on.
Just a quick question, do you need with that, do you still need a representative capacity signature disclosure?
You do not. This replaces that, yep.
That's good.
Again, there's just a couple examples there. July 1st, the Fair Appraisal Act came into effect. It required, look what it says there in the yellow box. Every contract for the sale of real property shall contain the following in no less than 8 points. It's basically information that appraisers cannot discriminate, right? Really, there were some really horrific examples that made the news. Really terrible conduct, right? And so this is a reminder. It says appraisers are regulated, and here's how you can contact the Bureau of Real Estate Appraisers. But what I thought was interesting is the language has, what is this, 1102.6G, every contract for the sale of real property. But 1102 only applies to residential property with 1 to 4 units. So how do you resolve that potential conflict? Is it every contract considered real property? But this is within 1102, so you'd think maybe that should be interpreted in light of the parameters of 1102, which is only 1 to 4. The fact of the matter is, we didn't want to bother figuring it out, so we added this to all of our purchase agreements. And then, just the last one, a little bonus here. This is going to happen in this upcoming December. So there's exceptions to arbitration, there's exceptions to mediation. One of the exceptions, I already mentioned before, is for small claims issues. There's other exceptions for what we call preservation of actions, right to preserve a statute of limitations, to record a lis pendens, and other injunctive relief. And so we started getting the issues. It's amazing to me how creative the legal field is. That says, well, once there's an exception, there's no further requirement to arbitrate or mediate. That's it. We filed a lis pendens. We had to preserve a statute of limitations that was happening tomorrow. So to have a lis pendens, what do you have to do? You have to file a lawsuit. right? Because what is all this pendants? It's a notice of a pending suit, right? So they say, well, there we go. It's an exception from the obligation to mediate or arbitrate. Therefore, we're totally out of that obligation. We're like, well, that's not how I would have read this exception. I would have read it, you know, just for that one particular act. So, anyways, what do we do? You know, how does everything become longer? That's how everything becomes longer. The red language, provided the filing party concurrent with or immediately after such filing makes a request to the court, which I assume would be a motion, for a stay of litigation pending any applicable mediation or arbitration proceedings, right? Because we don't want to hear that argument anymore. That just because you're late in filing your lawsuit to preserve your statute of limitations, that none of these other requirements apply. I mean, I thought that was kind of a specious claim, but when you start hearing enough, you're like, well, maybe we need to add a few words to address it to avoid that issue. What do you know? We're down to questions with no time for questions. But we took some during, so I appreciate you all coming.
Don't we have a whole hour?
We actually have till 11:30.
Oh, we do?
Yeah, we have a
I
little
thought we had
bit
to
of time
lie.
for, we have a little time for questions. If you're
Okay.
ready to take them.
I'm gonna slow down. I thought we had till 11, okay.
I want to say it's good that nobody really cares about the purchase agreement based on the amount of questions that we had before. No, but it's amazing how much like this form and this contract is such an integral part of real estate in the state of California, and that there's continued. So one of my professors in law school was Roger Bernhardt, and he liked to call Neil all the time and argue with him about why he thought the purchase agreement stank.
Right, yeah. That was true. That was Roger's subtle way of giving me his opinion, yes.
All the time. But anyway, yeah, if you have some questions, or
Yeah, I can stay. I have no problem. I just thought I had to
I think
get
I saw one in the back.
This is more of a curiosity versus like an actual question. So you guys do a fabulous job when it comes to the PSA for the residential properties and residential leases. I'm just curious, why not the commercial aspect of it? Because when I sometimes get the commercial leases, I cringe when it's a car doc.
Yeah.
Because I end up doing so many addendums to it, and I'm just curious if there's some reasoning behind it or anything like that.
Well, okay, so I'll give you, now that I have time, I can come down.
Give me the long version, please.
Right. So I'm going to start with the purchase aspect, the purchase and sale of commercial properties. So we have a commercial purchase agreement. We have a residential income purchase agreement. I've actually spoke with, is everyone here familiar with AIR, CRE?
Of course.
Right?
Yes.
I've spoken many times with him doing a comparison of our two contracts. And they're a lot more similar than people would actually believe. They're set up very differently. They have many different approaches, but we've done basically a side-by-side comparison. I forget, I did one a month and a half ago to realtors who practice in the commercial area. So we have devoted time to that. But the first and foremost thing is, and I don't know the exact number, but I'd venture to say 90% of all CAR members practice in the residential space. So where's CAR going to devote its time? To where its members are doing business, right? So when we create forms like the purchase agreement, every time we change our purchase agreement, we conform all of our other agreements. So we've conformed the residential income, we've conformed the vacant land, we've conformed the commercial, and then we have different paragraphs where the type of property sale warrants something being done differently, or something being added, or something being taken away. Like, there's no reason to have transfer disclosure language in a commercial purchase agreement, because that's not applicable. So that's kind of our starting point. What about commercial leases? We really see, if there was limited use of commercial transactions, even more limited use of commercial leases for CAR members as a whole. But that form is actually going to be reviewed this upcoming year. Last year's CAR, we do all of our forms through a committee, and we created a working group to look at all of our landlord-tenant forms. We had about like 40 to 50 landlord-tenant forms altogether. And the committee got through, I think, 8 or 9 of them this year. Most of them are probably going to involve nominal or consequential changes, but the commercial lease is one of them that's going to be tackled this upcoming year. The reason we created a separate, what we call study group, is because most of our members don't practice in that area. So we created a group where we invited people who do practice in that area to give us advice about what kind of changes need to be made. So yes, I'd have to say over the years, the commercial lease, was, probably, the stepchild of CAR forms, but it's going to get attention this upcoming year. And either by June, the release in June of 2023, or maybe December of 2023, there is going to be a substantial revision to that form. Okay? Anything else? I'm open. And again, I apologize. I thought I had an hour, and I apologize for my misunderstanding. But I'm ready to take questions either on what I presented or anything else you have about Sierra.
You talked about the TDR being complete as a requirement on section 2. Do you feel that checking yes or no is required, or can you write in unknown? Like, for example, the question that says, are you aware of radon on your property? And nobody out here has radon, nobody ever looks for it.
Right.
But if you say no, and the buyer finds it later, he says, well, you should have known. You just write unknown, and then it's up to the buyer to figure out whether those conditions exist.
So I don't think it's necessary to write in unknown, right? Because in part of section 2 that asks a series of questions says, are you the seller aware? And the answer is yes, I'm aware, in which case you provide an explanation. Or you check the box that says no, I'm not aware. No does not mean it does not exist. No means there's no awareness. Okay? Now, if the seller was actually aware, then the seller has committed deceit. If the buyer is able to prove that the seller was actually aware. But otherwise, I don't think any additional explanation is needed when the no box is checked. It's very simple. I, the seller, am not aware of this item, this event, this particular fact.
Does the same apply to the non-standard, the CAR form that's 4 pages of multiple choice questions and
The SPQ.
Right. So you were talking about the transfer disclosure statement, what we call the TDS. I know there's others that created, they call it the RETDS, Real Estate Transfer Disclosure Statement.
Yeah.
CAR's created their own supplemental disclosure that we call the SPQ, the Seller Property Questionnaire. And I think it's 4 pages long. All of the questions are phrased exactly the same way. Are you seller aware? Right? The only time where I think maybe you do something additional is if you have a seller who has not occupied the property. I would probably, attach a piece of paper. Seller has not occupied the property in the last whatever many years. Maybe they've rented it out, maybe it's been vacant, whatever it is. Maybe it was inherited property, right? If it's trust property, the seller is probably going to be exempt from having to complete a transfer disclosure statement. But if it's inherited property, there is no exemption, right? So in that case, I think it's probably warranted to give the additional information so the buyer can maybe think twice. Maybe I need to do my due diligence, which they should do anyway, but maybe it's kind of a trigger to pay more attention to their own due diligence in the case of the seller who is not occupied and really has no knowledge about the property at all. Yes?
Does CODE have any standard protocol for agents to follow in advising their clients on filling out the TDS and the SPQ?
Does CR have any standards for, filling out, these seller questionnaire items? The answer is yes. Give it to your seller. Have your seller complete it. Do not complete it for your seller. And remind your seller if there's something you do not understand. Call me, email, text me, message me, whatever the current, proper format is, and we can talk about it. But the number one recommendation we have for real estate agents in the field is do not fill out those forms for the seller.
But one of the problems that I know as a mediator I see regularly, and when I actually lectured to the Contra Costa Association of Realtors, I've been somewhat surprised that real estate licensees don't know the answer.
Okay.
Is how attenuated does some information, some act have to be before a seller is informed whether or not to disclose it? So I've asked it when I've lectured them, if you had foundation work done last year and you are filling out a TDS, do you have to disclose the foundation work? Everybody's hand goes up.
Okay.
And I go, okay, if the seller says they had the foundation work done 5 years ago, how many do you believe that the seller has to disclose it? A couple of hands go down.
Okay.
And I keep going, 10 years, 15 years. How attenuated, how far back in time does an event then become non-disclosable? And I always advise, you disclose everything, but that's not commonly known and understood by real estate licensees.
So it does not surprise me that it's not commonly known or understood, contrary to our efforts to make that well known and understood. So in our form, the seller property questionnaire, the SPQ, we specifically say in the generic question, no matter how far back in time. It says it in that form itself, okay? We also have a form that I know some attorneys up in the Bay Area really like. It's called a, oh my God, the DIA, the Disclosure Information Advisory or something like that. I'm not sure what the acronym, I'm pretty sure it's DIA. And there's information there advising a seller, how do you fill out these disclosure forms? And that information is in there as well. Now, all we could do is go out and teach, put information in our documents itself that explain the rule. I wish there was a bright line, right? And there's not. I imagine sometime in the future, after I've stopped practicing, real estate law, there's going to be some tech person that has a file, just like there's, title company records that, go back to Spanish land grants. Somebody will figure out and have every single disclosure that was ever made on a property, just like they do with Carfax, right? Everything that was done to a car, and there's going to be some repository that no sane buyer in their right mind is ever going to be able to work their way through and figure it out. And when that comes, it's going to be easy. You just give a link to that repository. Until that time comes, and then the advice is the exact advice that you've been given. How we spread that word is not something that CAR has a lot of ability to do, unfortunately. Yes?
Question, before the new form came out, some probate purchases, the probate purchase agreement was used instead of this. So should this be used or along with the addendum, or can that probate purchase agreement still be used?
Okay, so yes, we used to have a probate purchase agreement. We discontinued that last year when we came out with the revised RPA. We created what we called a PAPA, the probate agreement purchase addendum. So for any probate sale, you should use the new RPA with that PAPA addendum form that addresses those issues unique to probate. I would not use the old one. It does not have all of the information that's in the new contract, so I think it is a mistake to use that old agreement, or any old agreement for that matter. But given that we have a probate addendum, I think that's the best way to approach it. Yes, I'm sorry, that's your hand.
Yeah, I was just going to say on a practical level, for me, when the question comes up, should I disclose, the answer is right there.
Right.
But I wonder, has anyone had a problem by disclosing something too much?
I've never heard of anybody have a problem with disclosing too much. You know, I'm going to go back. I've got to find something. I read an article from the National Association of Realtors that talked about disclosure, or rather lack of disclosure. Okay. So one of the things, I'm sidetracking just a slight bit, one of the items, or one of the services available through CAR is a legal hotline. So all real estate agent members of CAR can call and speak to a lawyer for free. And when I go out and speak, people go, oh, tell us, you know, the top issues, you know, that the legal hotline is hearing about. For 30 years, 30 plus years that I've been at CAR, the top issue has never changed. It's disclosure or non-disclosure. That's the number one issue. Now I'm going to go back to this article I was reading from NAR. It was sometime earlier this year, and I've got to find it so I can cite to it more specifically. And they're talking about the incredibly high percentage of sellers and listing brokers that do not disclose. Okay? Now, maybe they think it's no longer material, right? Yes, there was a fire in the attic, but, you know, we put the fire out. Well, did you replace the burned wood beams? No. If you did replace them, did you replace them with the contractor? Or did you just go up there yourself with a couple of 2x4s and some nails, right? So, you know, obviously, you know, when we get examples like that, sure, that's a disclosure item, right? And you're absolutely right. If somebody asks the question, that means they themselves are thinking, there's something I don't want somebody to know, which is exactly why you should disclose it. Okay.
So to follow up on that, let's say there was a fire in the attic 4 years ago.
Okay.
And the disclosure says, fire in attic put out, or something like that.
Yeah.
Okay. To what extent do you believe that the listing agent and or the selling agent, when looking at that, has an obligation to go back to the seller and say, tell me more. When was it? How much did it cost to fix it? Do you have any documents? Or does the buyer's agent sort of get the stuff, give it to the buyer like lawyers look at form interrogatory answers and put it in the file, as opposed to, is there really an obligation to go back and say, tell me more, what, when, who, and how much?
Okay. So I think there probably is an obligation, although I don't want to exaggerate it because I don't want to create an increased standard of care in the industry. Right? but if, you know, I'm sure many of you, you know, if not all of you, read the Field versus Century 21 case, you know, which has language in there which in my view is dicta, but other cases have picked it up as if it wasn't dicta, that talk about a duty to
counsel and advise.
Thank you, counsel and advise. And so at the very least, if I was the listing agent and I see that, I would ask my seller some of those questions.
Right.
If I was working with a buyer, and I'm an agent working with the buyer and I see that, I would say, buyer, you're having a home inspector. Make sure the home inspector sees this and talk to the home inspector about, are there any extra steps that you need to do to investigate what happened there? Okay? At a minimum, I think those are some things that probably should need to be done.
In the supplement, there is that language at the top which is in bold and which is an admonition to buyers and sellers, essentially saying, put yourself in the position of a buyer. What would you want to know? What I wonder is how many agents actually look at that language and point it out to the clients.
You know, you point out something which is a big, well, it's problematic for the industry. I guess it's not problematic for any of you who are expert witnesses. And that is, you know, one of my colleagues is also up here in the Bay Area is fond of saying RDR, realtors don't read. And yes, you know, I have to acknowledge, I'm an attorney for the industry. I would like everybody to go through. I would like everybody to review the contract, to review the documents that they're providing to their client. You know, just so that you're familiar with what you're asking a client to do, right? That's sound business practice. But the fact of the matter is, right now there's something like 210 or 220,000 real estate agents. So there's going to be the cream of the crop who are doing most of the business in this state. But you have a large percentage of realtors who do 2 transactions a year, right? They're selling property for mom or their cousin or their nephew, and they don't take the time, right? And then it just becomes kind of a risk analysis, which is, do you think it's going to come back and bite you? Up front and then in the back.
Well, I guess my question is more of what's your opinion on, it seems to me that all the questions that we're posing in this room, it really highlights the fact that the education of realtors and brokers, or agents and brokers, maybe not brokers, maybe agents, is lacking. That we have a standard that we look at when we're doing these transactions. So what, in your opinion, can be done to improve the industry? Because in my opinion, I think a lot of issues can be avoided if agents just did their job.
Okay. And I'm thrilled that you asked my opinion. But I'm just a lawyer at CAR. I can't speak for CAR as a whole. Right? You know, it's interesting. There's some of our members who think that the bar to licensing and continuing to maintain your license through the minimum continuing education that's required for real estate licensees should be raised. The previous governor, Governor Brown, thought barriers to entry should be minimized. And when there were proposals to increase the educational requirement, you know, basically directed his staff to say, no, we don't want to increase barriers to entry into fields of business. Now, whether the current governor feels that same way or not, I do not know. And I would say CAR as an entity has been consumed the last few years with other issues that were more pressing. You know, there's a lot of attacks going on against the industry, additional disclosure requirements. They say that whole defensible space requirement is just so impractical. You have to say to yourself, how many more of those things have been proposed through the state legislature that CAR has had to fight off to try to keep the industry able to function as it is, you know, without getting to the efforts of raising everybody's level of awareness. So it's just not something that's easy to do, especially given the huge volume of numbers that are members in, you know, I said over 200,000. Gentleman in the back, and I thought I saw a hand somewhere on that side also.
Yeah, I wanted to just address some of that. I am a real estate broker, but I'm also, you may not like me because I'm also a lawyer. But I wanted to address that because I got into real estate because I sued brokers during the crash. You know, in 2004, 2005, transactions were actually labeled as like order takers. right? Because homes would transact really quickly. Now, what have we seen since the pandemic with rock bottom mortgage rates? Properties were flying off the shelves for 2 years.
Right.
I'm telling you that when I see my clients, and I represent executors and administrators selling homes, I'm seeing a lot of homes, and you would see this too, your neighbors are selling homes in 2 days. How can anyone with there's a level of responsibility on everyone. So I used to put a lot of onus on agents and licensees, but I'm also now looking at 10 years of now being on the broker side, that there's a little bit of onus on, and homes are high economic transactions.
Right.
And there's a little, at least a minimum level of responsibility on buyers. Buyers are telling their agents, waive everything, because they've gone through buyer exhaustion. And there's a little bit of like, hey, what are you guys doing? Like, the furnaces last like 10 years. You know, waive all inspections, you know, waive home warranty, you know, and I'm looking at all the transactions. Now I have to look at it differently because I see it, hey, I have my own risk management, right? But other agents don't. And I think Compass and all those, I don't know, all the big brokerages, they do have risk management, but at some point there are, we're all participants, are millennials who are buying their homes for the first time, buying a $1.5 million house in Moraga or something like that. They're waiving all inspections, and where are they getting the funding? They're buying a home for the first time, and mom and dad are knowing that their kids can't afford their homes, so with rock bottom mortgage
Okay,
rates.
so I'm gonna respond because I know we're coming up to 11:30 here. So CAR as an organization tries to make the law clear. We have an amicus brief program. I'm one of the authors of our amicus briefs. Parties who have a case that affects real estate statewide can ask CAR for assistance. We write briefs saying that parties have their own responsibilities for a transaction. Okay? We have language in our buyer inspection advisory and in our purchase agreement. Coming out in December, we have a new form coming out, which may be, inapplicable, but it's I'm trying to think of a non-contingent offer advisory.
Oh, good.
Right?
Yeah.
Now, we already had a form that's called a market condition advisory, that basically says, markets go up, markets go down, you need to, but this one is specifically directed at writing offers without contingencies, either without all or without some contingencies. To get that in front of the buyer saying, listen, our recommendation as a real estate agent who's giving you this form is that you have inspections, okay? Now, we understand there's other considerations, such as actually getting a property, but that onus is on you. You need to figure out what's more important to you. Writing an offer without having any idea what you're getting, okay? Or writing an offer with contingencies. I know some brokers who take listings that like accepting contingent offers because they don't want their clients to have a problem 3 or 5 years down the line. And what they tell their clients is, you know what, unless every single disclosure is provided up front, so there is no 3 or 5 day right of rescission, why not give the buyer a 3 or 5 day contingency? Give them that opportunity so that they cannot come back afterwards. And it's good for the buyers too, right? Because now they know what they're getting into, and they might find out that everything is terrible in the house. But better to make a decision with full knowledge than with half knowledge. So that's one of the things that we are doing to try to minimize that risk that, hey, every burden is on the real estate agent. It's not. When you're entering into a major transaction, you have to take some responsibility for that transaction on your own. Okay? So thanks, Sharon.
One last one.
Okay.
All right.